Well. You're listening to Gloves Off with Professor Buitrón. Alright then, I may say words on point, straightforward. No jibber jabber, everybody forward. Issues, facts and solution. Get it at Gloves Off with Professor Buitrón. Alright, what other thing is a revolution? Get it on point with Professor Buitrón. Gloves Off, no nonsense issues, politics, community. A better men for Laredo. Gloves Off, a revolutionary show with everything that you need to know. With Professor Buitrón. Watch ya!
Gloves Off is always on point. Bringing you the best on current issues, community affairs, and the happenings around us. This segment of Gloves Off is brought to you by the best, so pay them a visit. Check them out. This is Gloves Off.
Back at you in Gloves Off, and today we have a great array of individuals that are concerned here in Texas about a issue that affects many, and that is interference with child custody and parent alienation. I'll introduce the individuals that are here that we can see. We have State Representative Tracy King. Good morning.
Morning, Paul. Thank you for hosting this podcast on this very, very important topic.
Thank you for being here. State Representative Richard Raymond.
Hey, Paul. Good to see you, buddy.
Good to see you. We got City Manager Robert Eads. How we doing?
How you doing, Paul? How you doing, Sir Robs? Good to see everybody.
And we have City Councilman Dr.
Martinez. Hold on, Robert. You can take the mask off now.
Yeah. Look, Sir Rob. Look who I'm with here.
One of my favorite cousins.
How are we doing?
Oh, who's your favorite?
Lupita, tell him he can take his mask off now.
Yes, ya se la quitó.
No me ayudes, por favor, sir. Thank you. Oh, what are we doing on the show? Come on, let's go on the show.
We're touching base on interfering with child custody, and on the bottom we have Orlando, who started a group called Parent Equality, right? Equality for Parents.
Right. I'm a child advocate. I represent different family law reform groups. One of them is the Fathers' Rights Movement. Another one is Americans for Equal Shared Parenting, interference with child custody here in Texas. But what we do is we align ourselves with mothers and fathers, and our goal is just to create better outcomes for children.
The issue that we have here, basically throughout the state, is there's a penal code, which is 2503, which is interfering with child custody. And it's a state felony. And a lot of these are prosecuting, but a lot of law enforcement are not arresting person that is not allowing the custody or interfering with child custody. And so that we're kind of in a conundrum in here, in the sense that here in Laredo, most of the police basically say the DA will not prosecute. And you talk to the DA and says, well, we can't prosecute if we do not have any paperwork. So it's kind of backwards and forwards. So I think we have to, I've spoken to the district attorney, and he says, we have to end this. We have to understand that people sometimes have to get arrested for us to proceed. Maybe in the future, everybody kind of just plays along. But I want you, Orlando, to kind of fill us in on what happens with the alienation and what happens with some of this process.
Well, it's a good thing you brought up the law enforcement aspect of it, because I do have a background in it. Now, there are several sections of the Code of Criminal Procedures and the Penal Code that allows an officer to actually arrest on site. The Code of Criminal Procedure, Article 14.01, offense within view, allows a peace officer to make an arrest in the view of a felony. Penal Code 25.03 happens to be a state jail felony, which is interference with the child, with child custody. So when either an officer, their supervisor, or a district attorney refuses to actually enforce the Penal Code 25.03, they expose themselves to Penal Code 38.05, which is hindering apprehension or hindering arrest. And this is when an individual, and it doesn't state whether it's civilian or with any law enforcement agency, but when they take steps to hinder the apprehension or the prosecution of an individual for a crime, they themselves expose themselves and their departments to that risk. So from a law enforcement standpoint, they do have the authority to make an arrest on site for this violation. So anyways, in speaking to that, the reason parental alienation or interference with child custody is a big issue is because when a parent under a court order decides to unilaterally deviate from that possession schedule, that means the child now, one, their rights are being violated, because once a judge has given both parents a possession order, that child has access to that other parent. So when the custodial parent or non-custodial parent actually denies that child's access, one, the child's rights are violated, and two, the parent's rights are violated. Now, that's just the preliminary stages of parental alienation. When the parent unilaterally starts deciding that these orders, these possession schedules don't apply to me. And it's not just possession schedules. You see parents denying the other parent to school records, to school access, to medical records, to medical appointments. And it's, that's where it starts. It starts with the failure to enforce Penal Code 25.03. And I understand it's a state jail felony. No one wants to place parents in jail, but there's other options. Parents can be placed on deferred adjudication. They could be placed on probation. But if we don't have enforcement of 25.03, then the parental alienation phases just continue, and it just snowballs until there's some severe damage to the child. And a lot of times, that damage to the child, it's irreversible. It's lifelong. It goes right into adulthood with them. So it's very important that we start at the early stages to try and intervene in the parental alienation stages.
I'm going to introduce Dr. O'Connor, who just jumped in right now. Doctor, can you hear us?
Oh, he's on mute.
Good morning. Thank you. Can you see me and hear me?
Yes, we can hear you. How are you doing, Doctor?
We're doing well, thank you.
Parent alienation and so on and so forth. And we're talking also about the interference with child custody. If you can elaborate more on what happens to a child, and not only the child, what happens to everybody when this takes common place?
I think the most basic thing to keep in mind, if we transition to the legal perspective to the what happens to the child, is that innately, genetically, evolutionarily, in its most basic terms, our children are basically made up of mom and dad. And when a parent intentionally, purposefully attempts to sabotage, interfere, or prevent the relationship of the child, of one of the child's parents, the child basically is losing part of him or herself. Part of that identity, that self, is being taken away internally. And that is in addition to all the benefits, skills, aspects, life experiences that one of the parents and the parent's extended family could have offered the child. The child, in that respect, also loses all of that family relationships, that family connection, that family history, which is very important also to the identity of the child. The parent deals with quite a lot. Losing a child to parental alienation is not like losing a child to death, and it's not to minimize that the death of a child is not devastating. It certainly is. But the parent never gets to go through the loss of the child because the child's not really lost. Unless the parent has the ability to just totally banish the child from their own psychological makeup, the parent never really gets the opportunity to go through the grief process, the loss process. So the grieving is just ongoing, and parents oftentimes deal with ongoing anxiety, depression throughout their lives. And in talking with parents that have had a reunion with their children when their children were adults, it is much of a relieving experience and a healing experience to a certain extent, because they can't give to the child what they could have given, and the child doesn't get what the child could have received while they were developing. So even though there could be a reunion, there is still a loss. There's still no opportunity to undo the effects that occurred.
Understood. So anybody else have a question?
Now, if I could elaborate a little bit more. So what happens to the child with this loss of self? For the child, there's an emptiness. When that emptiness can turn into basically a constant sadness or depression as we know it. The other thing is that the child has lost a caregiver, a nurturer, and that means a loss of the part of the stability of the child growing up. And that's a great setup when a child doesn't have stability in the parental relationships or its upbringing. That's a great setup for anxiety disorders. And then all of that can lead to a higher chance of substance abuse disorders. And then that, of course, we're familiar that that can lead to increased juvenile justice or even adult justice involvement, if not already substance abuse treatment, hopefully. And then the rates of school failure, school dropout, illegal behaviors, and even suicide death is much higher among children who have dealt or undergone or had to endure parental alienation.
Okay. How can we, as a community, change things in your perspective for us to better enable or for that not to occur, kind of like the safety of children? How can we stop that? Number one will be with enforcement or not enforcement, or what would you say?
In terms of speaking about 2503 violations, I think considering this perspective that when that is seen, considering as more of a red flag, not as the final behavior, and that's a red flag to that there has been parental alienating behaviors going on far longer than the custodial parent or the non-custodial parent finally exhibited a 2503. And the reason I say a 2503 violation, the reason I say that is because first there has to be identification of parental alienation. And parental alienation behaviors by a parent can be very subtle to very overt. And I think 2503 violations are just very overt violations. And in my experience with both juvenile justice and adult criminal justice and statistics, and I'm sure other participants certainly know more than I do and can relate to this, it's similar to, like, the analogy would be serious violent offenders. By the time an SVO, serious violent offender, finally gets caught in that offense, more than likely they've committed on average 200 to 300 misdemeanor crimes before ever getting caught in the violent offense or entering the juvenile justice system. And that's analogous to the 2503 violation. By the time an adult parent is overtly violating a written law and disregarding it, more than likely there has already been a series, longitudinal pattern of alienating behaviors by that parent against what's called the target parent, or the non-custodial parent most commonly. And so using the 2503 violation as a red flag, and that it's really paramount to a pattern, and how it really is a red flag that the child's probably been enduring a pattern of alienating behaviors from the parent or one of the parents, I think is an important aspect to look at. So identification and looking at these incidences of 2503 violations, not just only from the legal perspective of how to enforce it, but what it really means, that probably what's been going on with the child and the parent. So identification is number one. And I think from the legal perspective in dealing with 2503 violations, looking at really that as a red flag, but then again, I think with the judiciary, much more education, just overt, balanced education to the judiciary about how subtle these behaviors can be, that they're a longitudinal pattern that can be ever increasing in severity, and I would say progression, but that's one and the same word almost. And then also educating the general public. It's a bruise not seen, because it's an emotional, psychological bruise, and it's an ongoing, progressive bruise. So because it's not seen, it's oftentimes, even though accounted for as an abuse, so to speak, because it's not readily seen, it's not readily identified. So overall, increasing education to the general population, to the judiciary, to law enforcement, I think are really important steps. And I think what is going on now progressively, such as with podcasts like this, with meetings, is part of that process, and it's an important process. I hope that answers your question.
Anybody else have any question on that? And how, I think the city will be nice to be involved in. How can we help the city deal with this issue due to the fact especially with law enforcement? What do you think should happen?
Well, I think with any behavioral health issue or whatever, or what I would say behavioral issue, you treat it such as that. And I think having enforceable consequences results for this type of behavior, if it's considered as red flag behavior to a long ongoing pattern of previous behaviors, the best way of helping extinguish it is to have dependable, progressively increasing severity of results. I think that it's completely understandable of how difficult it could be for this type of violation to be enforced as a felony, particularly when you have mothers or custodial parents, and more commonly it's mothers, but it doesn't exclude that fathers aren't involved in this, have multiple children and they're holding down a job or have other responsibilities. And to impose such a strict strict consequences at times, I think, unrealistic. But I think what's been proposed in terms of stepwise misdemeanor violations, ticketing violations with fines, similar to traffic fines that are, is a pretty good idea, because it offers a readily available consequence to the offending parent. It puts them on notice, so to speak. And although this is a little out of my realm, I will say that it gives some generation of revenue and payoff to enforcement of it for the local districts. And it
Let
is
me, could I jump in for a second?
Sure.
This is Richard Raymond, one of the state reps. Can anyone on the call inform us if there are model communities either in Texas or another part of the country of which you're aware, where they're doing either that in terms of misdemeanor citations, et cetera, or just a more effective enforcement of the existing laws with reference to this issue, where there's a notable, significant impact on that community in terms of fewer and fewer incidences of parents, preventing a child from seeing the other parent. Are you aware of, I won't say Minneapolis, but, some other city around the country or even around the state where they've really sort of embraced this issue and had a significant impact?
I believe, I'd like to add, I believe it's Oklahoma who has a statute where they do issue citations. I believe it was.
And do we know, again, do we know anecdotally or just that you're informed that Oklahoma City or Lawton, Oklahoma, or some other place where you really see a significant decrease in complaints by the non-custodial parents, that it, in other words, that it's not happening as much anymore?
Yeah, there's Michael Turi, an individual who also works with his own parental alienation group. He's done research on it, and he does have all the numbers. He has the contacts over in Oklahoma, and he actually modified a bill, and I believe he's going to submit it this coming legislative session. So if you want that information, I could certainly get a hold of him.
I just think it would be good, whether we set up some Zoom conferences like this with some of our leaders in the law enforcement community in Laredo, or moving forward when we get to session, to where we engage them to help give testimony or just to inform us about where something is being done, that it's working. My point is, we do this all the time, as Representative Chairman King will tell you. We don't invent everything in Texas. And if something's a good idea and it's working somewhere else, then we look at that. We've done it many times. And there are times when people look at us in Texas and things that we're doing well, and then they start doing it in other states. And so I'm just sort of thinking aloud that we really do need to identify if there are cities in Oklahoma, or even if we have, we feel like the whole state has improved in this area, where we can look at it and say, see, here are the results, real results, and then see if we can model after that.
If I can interject just a little bit there and address both the city manager and Dr. Marte, the councilman. Is there any way we could change Laredo, instead of it going into a felony, to have it as a citation for interference with child custody?
So I don't know if we have the statutory ability to make those calls at a local level. I don't know if that's in Austin where this would come to be. What I will tell you though is in speaking to our city attorney's office, municipal court judge, I think there's opportunity, and of course our law enforcement, police department, and others. We can probably get to something, as Representative Raymond is saying, a smart idea that's working somewhere else. we'll definitely, take a look at that and see if we can formulate something out that could work for us here as well. And so, yeah, we can definitely, at least from the city's end of this, to commit to looking to see how this issue can be remedied better. And if it's by something we can do locally, we'll take a look at that for sure. And if it's something that's at the state level, then we'll definitely work with Chairman and Representative Raymond as well, and to do that when they're back in session. Work up to that session date.
Yeah, because I think a lot of police here, of what I've seen, and when I've talked to them, is a lot of them are hesitant in arresting the mother. Okay, so they won't arrest. I understand. And so they won't enforce it. So they'll kick the can towards the DA and say he won't prosecute. Then you talk to the DA and he says, well, we don't have any paperwork. We need a paperwork. And then you go back to the police and the police says, well, we don't do incident reports or offense reports or what have you. So it's a continual kicking the can back and forth. Like I said, we've talked to Chilo, our district attorney, and our district attorney says that yes, it will prosecute, but it's not him that makes the arrest. It has to be them. And it's also very hard for us to, I don't want anybody being arrested. But if you give somebody a fine and now they have to go pay that fine, then they're going to understand that, that fine, how can I put it? They're going to pay, they're going to have to go in front of the judge and all that time, and it's going to be less of a chance that they're going to do it again. Okay. And also, and I'm in agreement with many, and we have on the podcast, he founded Penal Code 2503, Interfering with Child Custody. That's an organization out of San Antonio, Jorge Saldana, and we'll talk to him in a bit. But what many have stated is that if they get hit with a fine or jail, more than likely they're not going to do it again. And if that happens, the whole community right away is going to find out about it, and it's going to ease the continual abuse of interfering with child custody. Understand what I'm saying? You still have individuals that you're not going to stop them, but you're going to have a lot of people that are going to think twice now. That's my point of view. Jorge? Good morning.
Guys, I'm George Saldana. I'm the grassroots organizer of Interference with Child Custody, Texas Penal Code 25.03. While we're talking about, first of all, can everybody hear me all right? Because I have a new case on my phone. Okay. Yes. First, we're talking about fines. Yesterday, I went to Victoria to pick up my kids, and my ex-wife didn't show up. Currently, now I have to file a writ of attachment and a habeas corpus. But she's already been held in contempt by a civil court judge for 36 hours. And she's still, having this kind of behavior. So yeah, a fine, honestly, from everything we've been hearing here in Bexar County with the San Antonio Police Department detectives that have been at the Special Victims Unit, what they've been doing is they've been contacting these parents, giving them a chance to right their wrongs and start turning over the child. And from multiple detectives we've talked to, and from feedback we're hearing from other parents, is that these parents are telling these detectives that they need to, leave them alone, that it's a civil matter. So these detectives are now starting to refer them to the DA's office because they're upset that even the detectives are trying to mitigate these situations so nobody goes to jail, so no felony charges are being drafted up and charged on these parents. And these other parents are still egregiously violating the law and disobeying their attorney and disobeying law enforcement. This needs to stop. I mean, there's parents that have their rights. Rights have already been established. There's nothing immoral or illegal or unethical we're asking for. The law has already been legislated. We have all the documents and all the research that shows that children develop and prosper when they have two parents available to them in their lives. So it shouldn't any county in the state change the mindset and quit enabling that parent and to keep violating. What they should do is mitigate these situations out in the field easily for the betterment of the child. The judge has already rendered their order and already said any peace officer use reasonable efforts. So I think, just even writing an offense report or having, the officer call that violating parent and tell that parent that, hey, look, if you don't turn over the child, then you're going to draft charges up, and if you can go to jail for up to 2 years. When we talked to Webb County DA, they said that when they sent out target letters, that 90 to 95% of the violators stopped what they were doing. So instead of these police officers going out and telling people it's a civil matter, I think just a simple, hey, we're going to start enforcing this. If you're found guilty, you're going to become a felon and you can spend up to 2 years in jail. And I think that's going to resolve everything. That's my humble opinion.
I'd like to add that, George is correct. When an officer makes a scene under Texas Code of Criminal Procedures 14.01, an officer has the authority to arrest on site for offense within view as long as it's a felony. Now, again, just like the other parents have said, we don't want to send people in jail, but an officer on location doesn't have to force a child out of the other parent's arms and physically remove that child and give them to the other parent. But an officer can just merely state with his authority that either the parent releases the child or that parent is going to be taken into custody and booked into the county jail. And of course, there's very few district attorneys in the state of Texas that will prosecute 2503, but an officer's authority to arrest does not depend on whether the district attorney accepts the charges. These are two different agencies, whether it's the county, whether it's a municipal agency, they're two different entities from the district attorney's office. And from what I understand, I've never seen any SOP, which is standard operating procedures, that are shared by the district attorney's office and any law enforcement agency. So an officer absolutely has the authority to tell that parent, the one who's violating court orders, the one who's displaying felonious behavior, that either the child is going to be encouraged and released to the other parent per court order, or they're going to be placed into custody for interference with child custody, which is the felony, the state jail felony.
I'm going to interject just a little bit in talking about the standard procedures and policies. I requested it from the city, and the city's there. That's something that we need to, here in the city, I'm talking to both councilman and our city manager, we need to update that, because that's last time that was changed was in 1994. And it basically states that, and I'll read it, it's right here. It says, neutrality in civil actions. Members shall not be given aid or assistance in civil cases except to prevent the breach of peace and to cause a disturbance. I think we have to change that to kind of come back into from 94 to 2020. We have to, I think, the ways in there that we can change that. And a lot of other things that I've seen is that here in the last 5 years, there have been 0 arrests for the interference with child custody. So in 5 years, 0, that means that a lot of going on and a lot of harboring of emotions all over the place has occurred. And basically what we need to do is have to stop that. We want a better community. We're all here for a better community, and we're all here for the safety of our children. And that's number one. And we need to understand that. And I think that we need to not enforce it, but change it for us to all live better. I think that's what we would want to do, I guess. Anybody else?
Well, things have evolved, over the years, and you're absolutely correct. I mean, I was talking to you the other day about child seats. Interference with child custody was first legislated in the late 70s. Car seats from mid to the late 80s have evolved so much. So why are we on this topic still referring how they referred it back in the 70s, civil matter? The reason why this was legislated was because of parent statute. Parents pick up their children and the parents lose out on children. So legislated the UCCJEA and this law, interference with child custody, and since then, it's evolved. The last time it was legislated was in 2011. Before that, it was 2007. But yet, officers are still it hasn't trickled down the chain. Legislated since this, and they that it's a civil matter. It was before it legislated, and until then, and until now, you know, just need to change the mindset. You know, children do when they have two parents involved.
Representative King, what do you have to say? What do you think about it?
Well, it's been something for a variety of reasons that I can't go into here, but I have a lot of experience with this going back 40 years, over 40 years ago. And I was involved with the piece of legislation years ago that created mutual
I saw you have, so the credit is in the chase. I guess it's a positive 907.
I deposited last night.
Right. And I'm looking at it here. So I guess the question is, do we still need?
Are we back now on us? Yeah. And so I was involved with a piece of legislation many years ago that created or attempted to create a mutual meeting place whenever custodial and non-custodial parents were meeting up to deliver the children. And I did that in response to some constituents that had adversarial situations whenever they would show up, whenever the custodial parent or the non-custodial parent would show up to pick up the child. And I think that was somewhat helpful. But it's an emotional issue is what makes it so much more difficult than things having to do with car seats or things like that, because you're dealing with people's emotions here. You're dependent on people to do the right thing just because they think it's the right thing. And it's very, very difficult. And I did some homework on it, and I know that some of the district attorneys are reluctant to put the custodial parent in a felony position where they lose custody of that child that a court has already predetermined that was the best parent. And so then it forces them into the position of giving custody of that child to the non-custodial parent, or perhaps more commonly to foster care, depending on what the situation is in that particular deal. And but to me, it's a very, very important issue, and I know that children do better when they're raised with two parents. You know, I was raised in a household that went through many marriages and divorces, and so I mean, I have seen all sides of this from the child standpoint, and so I'm a strong believer in this topic. But it's just sometimes when things are this emotional, we need to keep looking for better solutions than what we have now, because what we have now probably works in the vast majority of cases, but it certainly does not work in some cases, and it's just, you know, if all adults acted like adults, then we wouldn't have this situation, but unfortunately they don't.
And that's what we again, like Orlando said, we don't advocate throw parents in jail. We don't even advocate to make them felons. All we're trying to do is, hey, just follow the order as the judge has already deemed in the best interest of our child. But when that parent does not return that child or give that child over, Now they're producing harm. All the research that's come out of the University of Texas that was grant funded by the federal and state government, all that research is online. Cynthia Osborne from the University of Texas took money from the Texas Attorney General with grant money, and all her research states that the child does better with two parents. So again, when that other parent retains that child, now they're going against the court order, they're going against the state law, and now they're doing more harm to the child. And when you're a joint managing conservator, just like I am, the only difference between me and the mom isn't that she's the better parent. It's that the courts awarded her to be able to dictate where the child resides. We still have the same rights. I'm supposed to still be able to dictate whether my child and my child should get certain sorts of medical treatment. I still get to decide what they do in school, but all those rights are taken from me. And then I have to go back into civil court and I have to keep fighting, and then they hold the children back. So if a parent does not turn the children over, maybe it is time to flip custody to the law-abiding parent that's going to do what's better for the child. I mean, that's another way to think of it, and I think Orlando could probably elaborate a little bit more on that. You're on mute, Orlando.
Yeah, when a parent starts displaying felonious behavior, you've got to question whether that parent should be custodial status. A lot of times in the cases that I've seen, that the parents, mothers and fathers who have come to me with their cases that I've reviewed and given some advice on, when the non-custodial parent stops fighting to be in their child's life, then that parent is going to be minimized or completely removed from the child's access. But if the custodial parent stops fighting, then that means that child will have both parents in their lives equally. So because there's no consequences, this alienation of the other parent increases, and it just compounds to where it's very damaging to the parent-child relationship. And that's just the secondary effect. The primary effects, the primary concern of this parental alienation and this failure to enforce 2503 is that the child gets damaged physically, emotionally, and psychologically. And many times it's irreversible damage that they carry on through adulthood. And that's why we see that over 80% of the prison population are males from fatherless homes. And it's not that fathers just automatically abandon their children. It's just that, one, they're minimized by family courts, which is another topic. But two, it's just that 2503, interference with child custody, is not enforced. So these fathers are either through a family court or through the failure of 2503 enforcement, they're just removed from the child's access, and that damage is just lifelong. So there needs to be some type of enforcement, and even arresting somebody and prosecuting them for a state jail felony. We often see that through plea agreements that these charges are either placed on deferred adjudication. They're always brought down. There's always a possibility to bring these charges down to a class A misdemeanor, class B misdemeanor. There are other options, but because there's no consequence at all, then this problem continues to grow, and it will continue to grow unless we see 2503 enforced on some level.
Can I piggyback off of what Orlando was talking about?
Yes, Derek, you can.
Hi, everyone. Derek Berry. Sorry. I'm in my mobile office today. I think one of the biggest problems here that we're facing, speaking from a legislation standpoint, is that parents are being refused the proper documentation, whether they choose to go criminal or civil. They're not given the proper documents on site to capture the infraction. And it's the very first obstacle and hurdle that a parent often feels and sees when trying to exercise their visitation, exercise, their right to pick up their children. Whether it's because of a standard operating procedure that says otherwise, and law enforcement, frontline law enforcement is taught something different other than the state law. SOPs don't supersede the Texas Penal Code. So it's a huge hurdle thrown in both custodial and non-custodial parents' way, because they're being refused the offense report while they're on site. So when we go to sit down at the table with legislation and talk about all these things, when we do the open records poll, there's not an actual feel, there's not an actual read on how far widespread this really is, how big of a problem this really is, because it's not captured. And that starts with how it's coded, how it's taken from the dispatcher, how that frontline law enforcement officer is then closing that call out. And parents aren't even receiving the offense report. Now, an offense report holds more merit, more meat and potatoes when they go in front of a judge. It's not just an incident number, and different municipalities call them different things. The terminology varies a little bit, but if the parents were to get that piece of paper to document the infraction and to actually show how many times this is occurring and the repetitiveness, when and if they choose to go to court, whether they proceed civil litigation or if they go to the criminal route through the DA's office, I think we get an actual feel. So the very first obstacle when we're doing all this is to think first steps, and the standardization of that offense report is at a bare minimum. I mean, these parents should be getting, when they go to pick up little Johnny or little Sarah, they should be at minimum getting a piece of paper, that offense report, that documentation, so they can move forward with whatever process is laid out in front of them, whatever they choose at that time. So it is, I just want to make everybody aware it's a bigger issue than even what we feel and see and talk about, because it's not documented and captured properly.
But in that change, or in that note, there's two things here. Number one, there's the state legislation, and then there's the municipalities' governance over law enforcement, and each law enforcement agency has to take credit. For example, who dictates what the city of Laredo Police Department does? So it's a city. So I'm glad that two representatives of our city are here. So we have to look into the policy and procedures of how it's being done as a start, number one. I think that maybe the city manager and the city council can form a committee with individuals and have you all on board to kind of show them and talk to them about the policies that need to happen for this type of infraction. Because right now, they're taking it civil. I don't know if we lost our city manager or our councilman, but I think that's number one that needs to go.
You know, hey, Paul.
Go ahead.
Hey, Paul, this Richard Raymond. So, yeah.
Hello, I'm here. I have a little bad connection. I apologize.
All right.
Okay. Let me just say something real quick. Can you all hear me?
Yes.
All right. So, yeah, I do think, as I'm listening, that if the city manager and the council finds that they really don't have discretion to create ordinances, if you will, that can address the beginnings of these issues with misdemeanor citations, then maybe that's something that we need to look at in Austin, is giving them some discretion. And not every city will do it, but some cities will. My sense is that in large part because of your tremendous advocacy, Paul and George and others who are on the call, that the city of Laredo is going to be open to it. I mean, I know that Chilo, our district attorney, has worked really hard on this issue. He cares about it a lot, but it is complicated, as Chairman King just pointed out. And so maybe we do look at that, Paul, is that I'm not saying we erase from the books the more serious penalties for those that are committing more serious violations, right? However, sometimes just being able to address it through ordinances where there are fines and so forth, that may be enough to make some significant corrections in terms of the actions of some of these parents. So if they don't, if Robert and Dr. Martinez and the rest of them find that they don't have that authority, then maybe that is something that we need to look at. I'm certainly willing to look at that, giving them the authority to have something locally where they're not going to, maybe they won't put them in jail, but then give them tickets. Then it's not so much about the police officer saying, well, I'm not going to take this to the DA because they've got so many other things to deal with, but they'll give you a ticket if it's, I promise you, those police officers will know, they'll know it when they see it, if a parent is purposely preventing the other parent from seeing the child. And maybe that's one of the ways we get started.
Absolutely, because a lot of the concern that when I talk to different police officers from the constables and the deputy sheriffs and our Laredo Police, they all have, well, what happens if it's the custodial parent comes out and says, I don't want to let him go with him because he does this or drugs or what have you, right? And I'm not going to allow him to go in there because he places my son or daughter in danger. Well, they can still get that infraction for that. And they still have the child there. They still retain the child. And they still keep the child in safety. So this is something that can occur. But now if it comes to the point that you have 2-3 of those infractions already, then things change, right? But well, I do think that.
Yeah, because I think if that happens, where it's, repetitive and done several times, I absolutely believe that law enforcement and prosecutors are going to look at it more closely because it just becomes more obvious, or at least they start digging in a little deeper as to whether or not the custodial parent is justified, if you will, because the other parent is abusing drugs or what have you, or if in fact that's just not the case. You see what I mean? You get a few of those sort of citations, and I believe that it just starts giving prosecutors a little bit more indication about what's going on.
One thing that hasn't been mentioned is the failure to enforce on any level of interference with child custody creates fatherless homes. Now, that's not to say that moms don't experience this, but predominantly the data shows that it's fathers who are denied access. But when it comes to a law enforcement perspective, a lot of the times people don't consider that the products of fatherless homes are the biggest risk that law enforcement officers face. Not just law enforcement, but we're talking about firefighters and all the first responders in general. The biggest threat that they face out in the field are those products from fatherless homes, from single parent homes. So there needs to be a little bit of discussion on that, because the data does prove that the results or the products of fatherless homes are the ones who create the mass shooters. When you look at crimes against property, crimes against persons, burglaries, thefts, robberies, assaults, family violence, murder, suicide, drug addiction, PTSD, psychotic disorders, all of these things can be traced down to the failure to enforce interference with child custody. So we need to talk about all the consequences that are possible or at our disposal in order to make sure that court-ordered possession schedules are adhered to, because it affects everybody. It affects the law enforcement personnel that's responding, just as it affects a parent that's being alienated, because these children are a threat. They're a threat to law enforcement officers and firefighters, EMTs, paramedics. So it's a danger to them too when it goes unenforced.
It's the same thing in juvenile courts. When we talk to juvenile justices, they've said the same thing, that 90 to 95% of these kids that are being cycled through the juvenile system are all coming from fatherless homes. Here we are, or at least I am, fighting to be in a relationship with my child. I mean, I've already been given an order. I've already had due process. I've already been told that, you know, I get these weekends, and I'm a deadbeat if I don't try. But then when I try, I'm stirring the pot. The state of Texas is giving these orders to me. So if the state of Texas will gladly take my child support, will gladly give me my visitation on a piece of paper, says that law enforcement can enforce the orders, I have a state legislated law, and I can't do none of it. I mean, Texas might have to getting out of the child custody game.
Okay. So George, let me jump in. This is Richard Raymond again. I think several of us who are on this call have been working on this for a while. So in many ways, you're certainly preaching to the choir that more needs to be done, and that if more is done, the likely impact is a positive one on the child. But where we have to thread the needle here, I think is pretty obvious at this point, to me anyway, is that what we have right now is not working very well. So you can scream and yell from the mountaintops about it not being enforced enough. The bottom line is it's not working very well. And I think we need to refocus on how we can how can we reshape this system? And so you heard me a little while ago, maybe that's the route to go. If we can do some things before the death penalty, if you will, right? Before we get to that, if we can do some other things, maybe we can prevent more people from getting to that point, right? To the felonious point, as was pointed out earlier. So those are my instincts, guys. I mean, just thinking about it, and I've been working with you guys and fighting for and with you guys for a while now, but I feel like, we've got to try something else. And maybe it is not doing away with the existing penalties. You leave that in the law for the courts, etc., because that's important, and because you do have some very exaggerated cases. But on the other hand, maybe trying to find something that does work. Let's look and see what Oklahoma is doing, but also let's look and see if giving the city's ordinance ability to where they can issue citations, maybe that's going to change the conduct. You know what I'm saying? Maybe that's the way to go. Because if we just sit here and scream about it not being enforced well enough as it is, I'm not sure with everything that we've got coming up, guys. Let me just tell you something, and Chairman Tracy King will tell you, this will be my 14th session and Tracy's 13th, or I forget exactly where he's at, but we've both been here a while. And this will be the hardest session we've ever been a part of because of the pandemic, okay? And there are a lot of other issues like this that are very important that will have difficulty substantially changing because of all these other things that are going on that have affected our economy and lives and the general public and impending continued pandemics, etc. So I'm trying to see if we can come up with something that maybe makes sense, that doesn't get as much pushback, but that could lead to more results in terms of the patterns of those who are preventing their children from seeing the other parent. So
if I may speak,
I think we need to think in those terms.
If I may add to that. Hi, this is Dr. O'Connor. One of the things that occurs with tickets is it affects our insurance rates, and we also accumulate points. And I think as drivers, whenever there's a ticket, we certainly have to pay the ticket, so to speak. But I think all of us in the back of our minds have the question, oh my gosh, how many points, or are we going to get points, or how is this going to affect the insurance rate? I wonder if the insurance commission or the insurance company would have an interest in this, because data-wise, with kids that grow up in single-parent households that have had issues of alienation, not only are there mental health issues that come about more predominantly, but it does affect their behavior, and issues of criminality or chances are increased with that. Juvenile justice involvement, substance abuse involvement, things such as traffic tickets are much more likely. because of a whole host of things. And we already know that the insurance companies take into account the neurologic development of kids when they set insurance rates. And that's the major reason why insurance rates drop somewhere, I guess, age 26 and 27, because they collect all this data and they know what their investments and expenditures are, and the likelihood of accidents for one reason or another in age groups less than that. And that's based upon, the age less than 27 or 26. I think the neurologic development at that time becomes much more matured. There's much better impulse control, much better decision making. So I think the insurance companies do consider the status of our kids as they get into adulthood. And I wonder if they would also consider that with citations such as this, that also has repercussions on the insured's status, or the number of points an individual collects with the state, driving points or citation points, because that could be also a natural consequence over time. If you gain too many points, then you end up having to pay a state a regular annual fee, and you could have your license suspended or taken away. And then what is your ability to be the custodial parent? So
I think all those things should be looked at. I mean, I'll tell you, I don't speed. You know why I don't speed? Because I don't want a ticket.
Exactly.
And it's for a lot of reasons, including not increasing my insurance rate. But I'm a state official. I don't have state official license plates anymore. But I really do try not to speed for a very simple reason. I don't want to get tickets. And so maybe this is a way we can look at it and look at, to your point, that we can look and see if it can affect them in some other way. But I promise you, if we have citations that are issued and somebody is a repeat offender, 2, 3, 4 tickets, then I do think that the likelihood is the law enforcement and the prosecutors will look at those cases more closely. So maybe again, guys, that's where my mind is going. Let's see if we can do something to enhance the system, not in a way that puts more people in prison, but that gets people's attention, okay? And that they stop doing this stuff.
Oh,
Absolutely.
If I may, I need to get off. I have another meeting on Saturday of all days. But this, to me, is a very, very important topic, and it's something that's as I alluded to earlier, I've lived with as a child, and so it's important to me. I've done some work on it. I want to continue doing work on it, and I know Representative Raymond's done a lot of work on this, and I look forward to working with everybody in this group on a piece of legislation that will try and get to a solution in those instances where, and we don't know how many of those there are because we don't have the data, but in those cases where people just refuse to be nice and do the right thing, as George was alluding to earlier, if everybody would behave like an adult and a parent, we wouldn't even be having these discussions. And so I look forward to working with all of you to try to come up with some kind of solution that is we can get through the legislature, and some kind of solution that's enforceable, because I don't remember whether it was Madison or Adams. One of them, forefathers said, no law works. It only works as long as people choose to obey it. And so we need to come up with something that the prosecutors and the law enforcement people can work with in order to help them do with their job. Because that they want the same things that we do. Most of them do, I believe. So with that, I got to run, but I appreciate your time, and I appreciate you setting up this meeting, Paul. And I appreciate the work that Representative Raymond's done over the years on this. So.
Absolutely. I was going to end this, and I want to thank everybody here, because we can go on, and this subject matter touches everybody, and it touches our community, or nephews, or sisters, or our child's. It touches many, many folks, and I want to thank every single one of them, you that are here, that showed time, and they're continuing that fight, because this fight's not over yet anyway.
Gloves Off is always on point. Bringing you the best on current issues, community affairs, and the happenings around us. This segment of Gloves Off is brought to you by the best, so pay them a visit. Check them out. This is Gloves Off.